Picture this for a moment. A woman named Linda loses her husband of 41 years. She is heartbroken, but she takes comfort in knowing he was careful with money, careful with paperwork, careful with everything. He told her many times, "Don't worry, you're taken care of." But 6 weeks after the funeral, she gets a letter from his old retirement account provider. The money, the savings he built for 30 years at the same company, is not going to her. It's going to his first wife, a woman he divorced almost 20 years earlier. Nobody did anything illegal. Nobody committed fraud. He simply forgot to update one small form decades ago, and that one form overruled everything else he ever wrote down, including his will. Stories like this happen more often than most people realize, and if you are over 60, or you are the child of someone who is, what you're about to hear in the next few minutes could save your family from the exact same heartbreak. Welcome back to Retire's Guide, the channel built for people who want to protect what they've worked their whole life to build. If this is your first time here, do me a quick favor before we go any further. Hit that subscribe button right now, because we talk about exactly these kinds of overlooked financial traps every single week. The kind of things your bank, your insurance agent, and even your own attorney might never sit down and explain to you in plain English. Subscribing takes 2 seconds, and it means you won't miss the next warning that could matter just as much as this one. Now let's get into it, because what I'm about to share isn't meant to scare you for no reason. It's meant to protect you, and by the end of this video, you'll understand exactly what to check, why it matters so much right now in 2026, and how a few quiet minutes of paperwork today could prevent years of pain for the people you love most. Here's the part almost nobody explains clearly enough. Most people believe their will is the final word on who gets what when they pass away. It feels logical. You write a will, you sign it, maybe you even have witnesses or a notary, and you assume that document controls everything. But that is simply not how the law works for a huge portion of what most retirees actually own. Bank accounts with a payable on death designation, retirement accounts like 401ks and IRAs, life insurance policies, and even some investment accounts operate completely outside of your will. These accounts have their own separate instructions called beneficiary designations, and legally speaking, those instructions almost always win. It doesn't matter what your will says. It doesn't matter what you told your children at the dinner table. It doesn't even matter what a judge personally thinks is fair. If the paperwork on file with the bank or the insurance company says one name, that is who receives the money, full stop. This single fact is the foundation of almost every beneficiary mistake we're going to talk about today, so keep it in mind as we go. Let's start with the most common mistake of all, and it is the one that caused Linda's story at the very beginning. It's the mistake of simply forgetting. Life moves fast. You open a retirement account in your 30s, you fill out a form, you name a beneficiary, and then life happens. You get married, you get divorced, you remarry, you have children, your children grow up and have children of their own, you change jobs 4 or 5 times, you move states, maybe you lose a spouse and find love again later in life. Every single one of those moments is a moment when your beneficiary designations should have been reviewed, and yet most people review them exactly 0 times after the original paperwork was signed. The account itself doesn't know your life changed. It only knows what's written on the form sitting in a file somewhere, possibly one you haven't thought about in 20 or 30 years. This is especially common with old retirement accounts from jobs people left long ago. You move on, you forget the account even exists in your mind, but it still exists on paper, with an old beneficiary still attached to it, waiting quietly until the day it suddenly matters more than almost anything else you own. Now let's talk about the second major mistake, and this one catches families completely off guard, because it involves something most people have never even heard of: the difference between something called per stirpes and per capita. I know those sound like complicated legal terms, but stick with me, because understanding this single concept could change how an entire inheritance is divided among your grandchildren. Let's say you have 3 children, and tragically, one of them passes away before you do, but that child has 2 kids of their own, your grandchildren. If your beneficiary form is set up one way, your 2 surviving children split everything, and your deceased child's kids get nothing at all from that share. If it's set up the other way, your grandchildren step into their parents' place and receive that share instead. Same family, same intentions, completely different outcome, all based on one small selection on a form most people filled out without ever truly understanding what it meant. Many retirees assume their wishes are obvious, that of course the grandchildren would be included if something happened to their parent. But financial institutions don't work off of assumptions. They work off of exactly what's written down, word for word, line by line. The third mistake is one that feels almost too simple to matter, but it causes enormous problems every single year, and that is failing to name a contingent beneficiary. Think of your primary beneficiary as your first choice, the person you want to receive the account. A contingent beneficiary is your backup plan, the person who receives it if your first choice has already passed away before you. Here's the problem. If your primary beneficiary is no longer living and you never named a backup, the account doesn't just automatically go to your other children or your spouse or whoever seems like the obvious next choice. Instead, in most cases, it falls back into your estate, and that means it now has to go through probate court, the same lengthy, public, often expensive legal process that having a beneficiary designation was supposed to help you avoid in the first place. Probate can take months, sometimes well over a year, and during that time, the money your family was counting on can be completely frozen, tied up in legal proceedings while bills, medical expenses, or funeral costs are piling up at home. A simple second name on a form, a backup choice that takes 30 seconds to add, could have prevented all of that delay and stress entirely. Now let's talk about something that quietly affects far more families than people expect, and it involves naming a minor child as a direct beneficiary. It feels natural, doesn't it? You love your grandchild, you want to make sure they're taken care of, so you simply write their name down as the beneficiary on a life insurance policy or a retirement account. But here's what most people don't realize. Financial institutions and insurance companies are generally not allowed to hand over a large sum of money directly to a child under 18. Instead, when this happens, the court often has to appoint someone called a guardian of the estate to manage that money. And that process can be slow, it can be expensive, and it can come with court supervision that lasts until that child becomes a legal adult. Even more concerning, once that child turns 18, many states require the entire remaining balance to be handed over to them all at once. No structure, no guidance, sometimes no real-life experience yet in managing a large amount of money. What feels like a loving, generous decision can unintentionally create years of legal complications, and later, a sudden financial windfall handed to a young adult who may not be prepared for it. There are much smarter ways to provide for a grandchild financially, often involving a trust or a custodial arrangement, but those require planning ahead of time, not simply writing a name on a form. Here's another situation that catches people off guard, and it has to do with divorce specifically. In many states, getting divorced automatically revokes an ex-spouse as a beneficiary on certain documents, like a will. People hear this and they relax, assuming the same automatic protection applies everywhere. But retirement accounts and life insurance policies often work under completely different rules, sometimes governed by federal law rather than state law, and that automatic revocation may not apply to them at all. This means a person could go through a divorce, update their will completely, move on with their life, remarry, build a new family, and yet their old 401k or their life insurance policy could still legally list their former spouse as the beneficiary, simply because nobody ever went back and changed that specific form. Years later, after that person has passed away, their current spouse, the one they were married to for the second half of their life, could be shocked to discover they have no legal claim to that account at all, because on paper, it was never updated. There's also the issue of beneficiary designations that conflict directly with what's written in someone's will, and this creates one of the most painful situations families can go through. Imagine a will that clearly states everything should be split evenly between two children. It sounds fair, it sounds final, but if one of those children was named as the sole beneficiary on a large retirement account years earlier, and that designation was never updated to match the new wishes in the will, the retirement account doesn't get split evenly at all. It goes 100% to whoever's name is on that specific form, regardless of what the will says. This can create not just financial imbalance, but deep emotional pain between siblings, family members who suddenly feel like one of them was favored, even when that was never truly the parent's final intention, simply because two different documents told two different stories, and the wrong one ended up being the one with legal authority. Now, let's talk about something a little more current, because financial institutions themselves are also part of this picture. As banks, insurance companies, and retirement plan providers continue to update their internal systems, merge with other companies, or shift to newer digital record-keeping platforms, old paperwork can sometimes become harder to track, harder to verify, or in some unfortunate cases, simply misplaced in the transition. If you opened an account decades ago with a company that has since been acquired, merged, or rebranded, there's a real possibility that the most recent version of your beneficiary information may not have transferred cleanly. This is exactly why reviewing your beneficiary designations isn't just about your own life changes anymore. It's also about making sure the institution holding your money has the most accurate, most current version of your wishes on file, especially if you haven't personally logged into that account or called that company in a number of years. So let's bring this together and talk about what you can actually do starting today to protect yourself and your family from every single mistake we just walked through. The first step is simple: make a list. Sit down and write out every account you can think of that might have a beneficiary attached to it. This includes obvious ones like life insurance policies and retirement accounts such as 401ks, 403bs, and IRAs, but don't stop there. Include checking and savings accounts, especially any with a payable on death or transfer on death designation. Include annuities. Include any old employer retirement plans from jobs you may have left years or even decades ago. Many people are surprised once they actually sit down and count, realizing they have far more accounts with beneficiary forms attached than they originally remembered. Once you have that list, the second step is to actually contact each institution and ask them directly, in plain language, who is currently listed as the primary and contingent beneficiary on this account. Don't assume you remember correctly. Don't assume nothing has changed. Ask them to confirm it in writing or send you documentation showing exactly what's on file right now, today, in 2026. You might be surprised by what comes back. Sometimes it matches exactly what you expected. Other times people discover an ex-spouse still listed, a sibling who has since passed away still named as a contingent, or no beneficiary listed at all because a form was never fully completed in the first place. The third step is to think through any major life events that have happened since you last touched these accounts. Did you get married or remarried? Did you go through a divorce or separation? Did you welcome a new grandchild into the family? Did someone you originally named as a beneficiary pass away? Did your relationship with one of your children change in a way that affects how you'd want things distributed? Each one of these moments is a perfectly good reason to update your paperwork, and the good news is that updating a beneficiary designation is usually far simpler than people expect. In most cases, it's a short form, sometimes available online, sometimes requiring a phone call, and it typically does not require an attorney or any major legal process. It's often one of the easiest, fastest pieces of estate planning you can complete, and yet it's frequently the most overlooked. The fourth step, and this one is especially important if you have minor grandchildren or you're concerned about a large lump sum going to a young beneficiary, is to have a conversation with a qualified estate planning attorney or financial advisor about whether a trust might make more sense for your specific situation. This doesn't have to be complicated or intimidating. Many advisors can walk you through simple options designed specifically for situations like leaving money to grandchildren, protecting a beneficiary with special needs, or making sure a large sum is distributed gradually over time rather than all at once. The goal isn't to make things more complicated than they need to be. The goal is to make sure your wishes are carried out exactly the way you intend, with no surprises, no confusion, and no unintended consequences down the road. There's one more mistake worth mentioning, and it's a quiet one that many people never even consider, and that's leaving a beneficiary field completely blank, or accidentally naming "my estate" instead of a real person. It might seem like a small technical detail, almost meaningless, but the consequences can be significant. When an account has no named beneficiary, or when the estate itself is listed as the beneficiary, that money typically does not pass directly to your loved ones the simple way. Instead, it gets pulled into the probate process along with the rest of your estate, meaning it becomes subject to the same delays, court oversight, and in some cases, creditor claims that the rest of your estate has to go through. For retirement accounts specifically, this can also trigger a much faster required withdrawal timeline than if a person had been named directly, which in turn can create a larger, more immediate tax bill for whoever eventually inherits that money. In other words, one blank field or one wrong selection can quietly turn what should have been a smooth, private transfer into a public, taxable, drawn-out legal process. It's a detail easy to overlook and expensive to ignore. Another area worth a moment of your attention involves any digital or newer types of accounts you may have opened more recently. Things like online investment platforms, robo-advisors, or newer retirement savings apps that didn't exist when you first started planning your finances decades ago. These platforms often include beneficiary designation options buried somewhere in account settings, sometimes in a section many people never click into during the sign-up process. Because these accounts feel newer and less traditional, people sometimes assume they're automatically covered by their will, or they simply forget the option to name a beneficiary even exists within the platform. If you've opened any financial accounts in the last several years, even ones that feel small or relatively new, it's worth logging in and checking specifically whether a beneficiary has been named, rather than assuming it was handled automatically somewhere along the way. It's also worth pointing out that beneficiary rules are not always identical from one type of account to another, even within the same family's finances. A life insurance policy may follow one set of rules, a workplace retirement plan may follow a different set of federal guidelines, and a personal bank account with a payable on death designation may follow yet another set of rules specific to your state. This is exactly why checking each account individually matters so much, rather than assuming that fixing one document, like updating your will, automatically takes care of everything else connected to your name. Each piece of paperwork lives in its own little world, governed by its own rules, and each one needs its own individual attention to make sure it actually reflects what you want. I want to take a moment here and talk directly to anyone watching this who feels a little overwhelmed right now, maybe even a little anxious, thinking about how many accounts you might need to check. That feeling is completely normal, and I want you to know you are not alone in this. Most people, even those who consider themselves organized and on top of their finances, have at least one outdated beneficiary form sitting somewhere in their paperwork without realizing it. The fact that you're watching this video, the fact that you're taking the time to learn about this today, already puts you ahead of where most people are. You don't have to fix everything in one single afternoon. Start with one account, make one phone call, confirm one beneficiary, then move on to the next one when you're ready. Small, steady action is what actually protects a family, not perfection, and not doing everything all at once. I also want to gently mention something important for anyone watching this on behalf of an aging parent or a loved one. If you have a mother, father, aunt, uncle, or close family friend who is getting older and may not have reviewed their beneficiary designations in many years, consider having this same conversation with them. It doesn't have to feel heavy or uncomfortable. You can simply say something like, "I watched a video about people forgetting to update old retirement accounts, and it made me want to make sure ours are current. Want to check together?" Framing it as something you're doing together, rather than something you're worried about regarding them specifically, often makes the conversation feel much lighter and much easier for everyone involved. Let me share one more example, because I think it shows how this issue isn't just about large sums of money or complicated family situations. It can affect even the simplest, most loving families. Consider a man named Walter, married to his high school sweetheart for nearly 50 years. They raised 3 children together, and on paper, everything about their finances looked organized and thoughtful. Walter had a will, he had it updated by an attorney, and he genuinely believed everything was in order. What he didn't realize was that one small savings account, opened back in the early 90s at a local bank that has since been bought out twice by larger banking companies, still listed his late mother as the beneficiary, a woman who had passed away over 15 years earlier. Nobody had ever gone back to update it because nobody knew it needed updating. When Walter passed away, that particular account quietly became tangled in legal limbo, not because of any conflict within the family, but simply because the named beneficiary no longer existed and no backup had ever been added. It took his children months of phone calls, paperwork, and patience to finally resolve something that could have been fixed years earlier with a 5-minute phone call. Walter's story didn't involve any drama, any second marriages, or any complicated family dynamics. It simply involved time passing quietly in the background while one small form sat untouched. Stories like Walter's and Linda's matter because they remind us that this isn't only a concern for people with complicated finances or blended families. It's a concern for absolutely everyone who has ever opened a bank account, signed up for a retirement plan, or purchased a life insurance policy, and then simply moved forward with life, the way we all naturally do. None of us mean to leave these details unattended. It happens because life is busy, paperwork from decades ago feels distant, and most people assume someone would have told them if something needed to be updated. The truth is, no one is going to send you a reminder. The bank isn't going to call you up and ask if your beneficiary information still reflects your current life. That responsibility quietly sits with you, and the good news is, now that you know it, you're in a position to do something about it before it ever becomes a problem for the people you love. Now, before we wrap up, I want you to think back to Linda's story from the very beginning of this video. Her husband wasn't careless. He wasn't irresponsible. He simply forgot about one small form from decades earlier, a form that quietly outranked his will, outranked his verbal promises, and outranked even his own final wishes. The system isn't designed to be cruel. It's simply designed to follow exactly what's written down, nothing more and nothing less. That means the power to prevent a story like Linda's isn't complicated, expensive, or out of reach. It's sitting right there in a form you can review, update, and confirm, often in less time than it took to watch this video. If this video opened your eyes to something you hadn't thought about before, I want to hear from you directly. Scroll down right now and leave a comment letting me know which account you're planning to check first. Your old 401k, a life insurance policy, a savings account, or maybe an annuity you haven't looked at in years. I read every single comment, and honestly, some of the most powerful stories on this channel have come directly from viewers sharing their own experiences, sometimes painful ones, sometimes ones where they caught a mistake just in time before it became a real problem. Your comment could be exactly the warning another viewer needs to see today. And if you have a sibling, a parent, a close friend, or anyone in your life who might benefit from hearing this, please take 30 seconds right now and share this video with them. You never know whose family this single video could quietly protect. Sometimes the most loving thing we can do for the people closest to us isn't a grand gesture. It's simply passing along the right piece of information at exactly the right moment, before it's too late to fix. Before you go, make sure you're subscribed to Retire's Guide, because we're not done covering the financial blind spots that affect people over 60. There's another mistake, one connected to required minimum distributions and how they quietly interact with these very same beneficiary designations that we haven't even touched on yet, and it could affect how much your family ends up keeping versus how much disappears in unnecessary taxes and penalties. We'll be breaking that down in detail very soon, and trust me, you're going to want to see exactly how it works before it potentially affects you. Stay close, stay informed, and as always, thank you for spending this time with us today. We'll see you in the next one.